freedom of speech,
fundamental rights,
freedom of conscience,
academic freedom,
freedom of press,
and the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights in Education.
Happy holidays and welcome back to So to Speak, the free speech podcast, where every other week we take an uncensored look at the world of free expression through personal stories and candid conversations. I am your host, Nico Perino, and today we investigate the original meaning of the First Amendment. How much speech did our founders really intend to protect when they enumerated the freedoms of speech and of the press in the Bill of Rights in 1791? The answer? Well, it might surprise you. That is, so long as you believe our guest on today's show. Judd Campbell is an assistant professor of law at the University of Richmond, and he is out with a new provocative article in the Yale Law Journal. And the article argues that most of the speech protected by today's interpretation of the First Amendment might not be protected by a true originalist interpretation of the First Amendment. Say goodbye in that case to Texas versus Johnson, Boy Scouts of America versus Dale, Citizens United versus FEC, and Snyder versus Phelps, not to mention New York Times versus Sullivan, and much else from today's core First Amendment jurisprudence. Professor Campbell's article is titled Natural Rights and the First Amendment, and Harvard law professor Cass Sunstein recently wrote that it might well be the most illuminating work on the original understanding of free speech in a generation. In his article, Professor Campbell argues that the founders' understanding of the freedoms of speech and of the press rested on a multifaceted understanding of natural rights that no longer survives in American constitutional thought, and that these rights were expansive in scope but weak in their legal effect, allowing for restrictions of expression to promote the public good. On today's episode, I speak with Professor Campbell about his article, and it gets quite wonky. I should say we reach perhaps First Amendment nerd level 1000, so I ask you all to prepare yourselves. We explore some concepts that, while absent from our constitutional discourse today, were central concepts to the founders' understanding of rights. Concepts such as natural rights, positive rights, and inalienable rights, social contract theory, and common law. And we close this conversation by asking ourselves, if the argument is true, and the founders really didn't intend the First Amendment to protect as much speech as it does today, what, if anything, should we do about it? This conversation was recorded over the phone. Please enjoy. Judd, thanks for coming on the show.
Oh, absolutely. Thanks for having me.
So let's begin by discussing the origin story for your investigation into the origin story of the First Amendment. What inspired you to look into this history?
Well, I was interested in how ideas about speech and press freedoms were changing in the 1790s, and in particular about how partisan developments were forcing Republicans to come up with new ideas about speech and press freedoms. And in particular, the impetus for that shift was juries were being hand-selected by Federalist marshals. And originally, having juries hand-selected was thought to be a way of protecting rights, that we would have men of wisdom and discernment who would be on the jury, who would be better able to protect property rights in particular, but other forms of rights as well. And what people began to realize in the late 1790s, Jefferson originally in 1797, a full year before the Sedition Act, was that having juries hand-selected by Federalist marshals was actually going to lead to a biased jury. And in particular, in cases involving seditious libel, the biased jury was likely to find that the publications that were hostile to the Adams administration would satisfy the requirements for false and malicious speech. And so they were beginning to rethink these ideas, and in order to make my case that these ideas were changing in the late 1790s, I had to lay out how people were thinking about speech and press freedoms in the late 1780s when the ratification debates were taking place and Congress first proposed the Bill of Rights. And what I came to realize was there was actually a lot of new things to say about speech and press freedoms that I hadn't anticipated, and in particular, thinking about the interrelationship between natural rights and positive law. And so that's what the piece really engages with, is how is it that the founders thought about speech and press freedoms as natural rights, and what were the implications of that for restrictions on governmental authority. So that's really the nexus of the piece. Is I was interested in a sort of changing views of speech and press freedoms later on, but that got me interested in where things began.
So you say in your article that speech and press freedoms referred in part, as you say, to natural rights that were expansive in scope but weak in their legal effect. And you say that this allowed for restrictions of expression to promote the public good. What are natural rights and what are positive rights? Because I think those are important to understand if you want to understand your thesis.
That's right. So we've really lost touch with the political philosophy of the founding and the way the founders began thinking about constitutional ideas was to start with an underlying theory of political philosophy. And that underlying theory was social contract theory. So this will be familiar to some people who are aware of Locke's idea of having natural rights. And basically the gist of it is that if we want to figure out what it is that government ought to be doing and government ought not to be doing, which is the essential problem of political philosophy, then one way of going about that enterprise is to just ask, well, what would things be like without a government? What would what would lead people who had no government to decide to form a government, and what would be the limitations that they would impose upon doing that? And so social contract theory is basically a thought experiment. It's one that tries to ascertain what the proper role of government is. And so the thought experiment begins with the idea that, well, even if we didn't have a government, we would have certain liberties. There are things that we can do that don't require a government in order for us to do them. And so when the founders talked about freedom of speech, they didn't necessarily call it freedom of speech. It wasn't a technical term of art. What they would talk about was the freedom of discussion, the freedom of opinion, the freedom of communication. One of my favorite turns of phrase was the freedom of the tongue. And the idea was without a government, we would be able to engage in communication with each other. And so speech was easily identifiable to the founders as a natural right. And then what social contract theory provided, in addition to the idea of natural rights, was some understanding of what it is that humans, when agreeing to join a political society, what were the terms that they would agree to. And so the basic terms of the social contract, as the founders understood it, was that people would agree that the government should try to help protect natural rights, but that it was okay for the government to limit people's ability to exercise their natural liberty if doing so was in the interests of the political society. And so that's the basic starting point, is this idea of social contract theory. And so what the paper does is it's trying to tease out, okay, we have this ability to engage in speech. We have this countervailing principle that the government can limit speech in the public interest. Then we have all this virulent debate about, well, what types of speech restrictions are okay and which types aren't. And so here, one of the points of the paper is to say, actually, in trying to figure out what types of speech restrictions serve the public interest and which types didn't, there were competing methodologies at the founding. And so you have one group that is generally associated with the Federalists, who were very elite, lawyerly types. And so they wanted to have they wanted us to look to the common law to figure out what the proper limitations on governmental authority were. And the common law, in general, supported a broad ability of the government, not unlimited, but a broad power of the government to punish speech that was malicious and false, that was defamatory of the government. And so if you could show that somebody was engaged in a false and malicious attack on the Adams administration, for instance, then you could be prosecuted consistent with the common law. But there's another understanding of how we would ascertain the limits on governmental authority that the Jeffersonians championed, and that was, we don't need these elite lawyerly types to tell us what's in the public interest. We can decide for ourselves as a people what sort of speech restrictions are permissible. And so one of the points of the paper is to say, look, there's a starting point that is common to the founding generation, or at least the founding era elites who are writing about this. And that starting point is an understanding of social contract theory and natural rights. But actually, there's a lot of diversity in founding era thought as well, because they had different ways of cashing out exactly what the proper limitations on governmental authority were.
Yeah, so one of the things that I think many people think about natural rights is these are a trump card on government. But from reading your paper, the founding era elites didn't think that.
That's right. We tend to think about natural rights either in terms of like a Thomistic Catholic view, or as a libertarian view. Natural rights at the founding are actually a starting point for everybody. It's not limited to people who have an understanding of rights as derived from God, and it's not limited to people who have sort of proto-libertarian views. And so there's actually some diversity in founding era thought about what natural rights are. But in general, natural rights rhetoric develops in the late 17th century as a forceful argument for having popular control over restrictions of human liberty and property, and as opposed to having monarchical control over those. And so the thrust of natural rights reasoning in the late 17th century, and this is what Locke is writing about, is a defense of parliamentary sovereignty as opposed to monarchical power. It's really not about the individual versus the state. It's about Parliament versus the king. And that's the same view of natural rights that underpins the movement for American independence. So the American argument is we have these natural rights, and therefore we cannot be controlled in the exercise of those natural rights by an assembly to which we do not have representation, in which we do not have representation. And so again, the argument that the founders were making during the Revolution in favor of their natural rights and in defense of their natural rights was all about representation. It wasn't about individual versus the state. It was about who has control over governmental decisions.
So let me know if I'm getting this right. Thomas Paine said that a natural right is an animal right that you have in a state of nature. So in a state of nature, you can speak freely. You can, I guess, create for yourself property or a sphere of influence, yada, yada, yada. But then when we enter into a contract with a community, social contract theory, we sort of give up those natural rights so long as there's not a monarchy. Is that my understanding?
There are different ways of thinking about it. So there's not one common account for exactly how the social contract exactly what it does with respect to natural rights, although one of the things that I point out in the article is that for the most part there is a common endpoint, which is that natural liberty is is regulable in the public interest. So on one account, when you enter in the social contract, you give up your natural rights, or at least you give up some of your natural rights.
So long as there is this, so long as you can justify it in the public good. But that seems like a hole to me that you could drive a truck through. You have in your article a quote from Joseph Priestley, who said there's a real difficulty in determining what general rules respecting the extent of the power of government or of governors are most conducive to the public good. And I read that, I'm like, well, duh. If you say a trump card for any natural rights argument is the public good, then you could, the Soviet Union, Stalin made arguments, that their pogroms and their limitations on civil liberties were in the public good. That's sort of the fallback of any tyranny.
That's right. And so the arguments that are made around the public good are often ones that justify suppression on the basis of some sort of government effort at censorship over dissent. And so this is a sort of recognition that I think underpins the movement in free speech law in the 20th century, a sort of recognition that the existing understanding of speech and press freedoms as being regulable under the police powers was underprotective. And so this is what, Holmes and Brandeis, Brennan, and so forth are pushing against in the early free speech decisions, and so I don't disagree with that at all. But that is a recognition of. The problem here is that the founders they were operating within a different mindset. So for them, the basic problem was not having control over restrictions of natural liberty, and so when the king would try to engage in prosecutions of those who were critical of the government, for instance, the prosecutions would have to go to a jury, and the jury was composed of colonists who were sympathetic to those who were making the criticisms, and so the jury would nullify any sort of effort of prosecution. And so for the founders, the way they're thinking about this is what we really need is we need to maintain control over our own restrictions of natural liberty. And for them, that was enough, because for them, the threat was abroad. The threat was somebody else imposing restrictions on speech, restrictions of speech on them. Whereas once we get to the 1790s, and this is where the inspiration for the paper really came about, the Jeffersonians start to realize, hey, wait a minute, restrictions on speech don't just come from abroad. Sometimes they come from within our own society, and we really need to rethink some of these ideas. And so I think Jefferson and Madison really recognized exactly what you just said, that there's a truck-sized hole in the existing theory, and it's a truck-sized hole that allows for very speech-suppressive rules like the Sedition Act, and so this is something that the founders became aware of, but I think went into the drafting of the First Amendment without a good appreciation for exactly how big that hole was.
So the main concern of the founders in the 1770s and the 1780s was self-representation. And they felt that if they could get that representation, then that would be enough of a check on tyranny. And to the extent that self-representation made laws in the public good, it was sort of almost unquestionable their right to do that.
That's right. So that's not the only thing that's happening with respect to rights, but that is overwhelmingly the dominant aspect of American rights discourse. So when Madison is pushing for the Bill of Rights, his primary argument for the Bill of Rights is the enumeration of these rights will help educate Americans and make them better aware of our rights so that we can, through the political process, vindicate those rights, which of course to us is a very foreign way of thinking. Usually when we're thinking about rights, we're thinking of checks on the political process that are imposed through certain separation of powers, particularly through the judiciary. And that's not the primary argument for Madison.
So the confusing thing for me is that even still at this time, though, they thought that those rights could be bounded by things that the legislature determines are in the public good. For example, we talk about the enumeration of rights in the Bill of Rights. They thought, Alexander Hamilton famously asked in Federalist 84, and you talk about this in your piece, why declare the things that shall not be done which there is no power to do? I guess a way of rephrasing this question is, so the founders had an idea of natural rights, but they also had the separate concept of certain natural rights that are inalienable rights.
That's right. So there are, I think, two things that are happening here. So one is that the founders had a sense that what sorts of limitations on governmental authority should exist. So these are limitations where an existence of a power or exercise of a power in a certain way would not promote the public good. What those were understood to be derivable through custom. So we could have a public debate about legislation that is or isn't in the public interest. That's absolutely true. So sort of what you just said, where you're starting out the comment, I think is right, that there is authority for the legislature to have debates about what speech regulations promote the public interest. But at the same time, the founders understood that, we had actually had a lot of these debates already, and we had come to recognize that there were certain restrictions on governmental power because, and the reason why those existed is because we had already had a appreciation that those restrictions were necessary in order to promote the public good. And
would those be inalienable rights?
Sometimes those are one and the same. So the idea of inalienable rights is that when people are entering into a social contract, there are some things that they cannot sacrifice, because in order to sacrifice those things, they would have to part with their humanity, that there are some things which we just cannot control. And so, for instance, you cannot, the way the founders thought about the freedom of opinion is you cannot control your own thoughts. And so there is, it would be tyrannical for us in a social contract to give up to the government an authority over what we think. And so the notion is, if I see some object or I perceive some hostility on the part of the government or whatever it is that I'm thinking, I have no volitional control over that. And so the founders used that idea, the inalienability of one's thoughts, to justify an ability to speak what it is that you were thinking. And so that's an important part of it.
But not unless what you were thinking was untrue.
So that's right. Although the key point here is less on whether it's true or not, and more on your intent. So the focus here is on. So remember, the idea of freedom of the mind is focused on the non-volitional aspect of your thoughts. That I don't have control over what I'm thinking, but I do have control over whether I lie about what I'm thinking. And so as long as you are speaking your thoughts with a good intention and truthfully conveying what you're thinking, then the founders thought that could not be restricted, that was part of the inalienable right of speech.
So it not only it had to be false, but it also had to have a malicious intent. That's
right. So it had to be false, and it had to have some sort of bad intent. And so of course, the actual malice standard in some ways picks up on that, although one of the debates that's happening at the founding is the extent to which you can presume malice simply through what the words say. which is something that for much of American history, the simple fact that you had said a certain set of defamatory words was itself proof of malice, and so that's what the actual malice standard is backing away from. But this is an important limitation because it meant that when people are arguing in the late 1790s about whether certain folks have committed sedition or not, what you're going to have is you're going to have a jury that has to ask questions about intent. And the Sedition Act in particular specifically said that individuals had a right to have a general jury verdict and that there was a truth defense. And so you could come forward with evidence that what you were saying was not your own manipulations, but was actually, or contrivances, but was actually true. And that ends up being where the problem of jury selection intersects with Jeffersonian thought. So if you have a jury that's hostile to Jeffersonians, then of course they're going to perceive that criticisms of the government are made maliciously. And so the basic problem here is even if you're focused on malicious speech and you're limiting governmental power to restrict malicious speech, you can still have massive amounts of suppression of actually well-intentioned speech because often the government isn't actually, the decision makers are biased. And I think that's the same concern that's undergirding New York Times versus Sullivan, that you have a Southern jury in Alabama who has to decide on all the factual issues at issue in a case involving defamation by the NAACP and other civil rights organizations against a Southern official. And so there's a recognition on the Supreme Court's part, this is not in the opinion, but it's very much in the background of the case, that we need we need rules with respect to the protection of speech that help protect us, not just based on what rules would be best in a perfect society where the governmental officials were always doing the right thing, but what rules do we need in a society where we recognize that the governmental officials and juries often don't do the right thing. Often they have their own biases that would lead to the suppression of actually well-intentioned speech. And so this is one of the, I think, most difficult aspects of trying to sort of asking the question, what do we do with the history? Because it's very clear that the founders were okay as a general matter with restricting speech that was false and malicious. But they also thought that there should be only speech restrictions that promoted the public good. And so we might come over the course of history to think that certain power over false and malicious speech may, in the end, not actually be in the public good because it chills too much useful speech. It gives the government too much authority to suppress dissent and so forth. And so I think this is a challenging aspect for thinking about the relevance of history.
So when I first read about your article, before I actually read the article, the implication to me was that if you want to hold an originalist interpretation of the First Amendment, much of First Amendment jurisprudence, or at least modern First Amendment jurisprudence, would have to go out the window. Texas v. Johnson, you write, Boy Scouts of America v. Dale, Citizens United v. FEC. You don't say these need to go out the window, but you do say that that could be the implication. Snyder v. Phelps is another one. But in the course of this conversation, my thinking is that the only thing that would really have to go out the window would be current defamation law. One could argue that Snyder v. Phelps, the Westboro Baptist Church in that case, was engaged in expressive activity that was the true expression of one's own views. Cabinet, of course, by well-intentioned. I don't know if it was well-intentioned, but who defines what's well-intentioned? It seems to me that perhaps United States v. Alvarez would have to go out, because in that case, the Stolen Valor Act prohibited people from lying about certain veteran statuses. But most of the other stuff, absent defamation law and out-and-out lies, could probably stay. Texas v. Johnson probably could. You could argue Boy Scouts of America v. Dale probably could. Am I wrong there?
Well, I think it depends on what sort of originalist or view of the relevance of history to modern constitutional doctrine, what sort of ideas you have about those methodological issues. So if your view is that what we ought to do today in terms of constitutional law, the sort of restrictions on governmental authority that are enforceable in court, if your view is that that set of legal doctrines ought to be exactly the same as the set of legal doctrines that existed at the founding, I think a lot of modern law has to go. And so there's no indication in the historical record that anything that we would call expressive conduct, so not verbal speech, but actions that in some way convey ideas or promote speech in some second-order sense, political donations or association with others.
Flag burning, protests outside of funerals.
That's right. There's no indication that those sorts of activities would have been covered by this inalienable right. So remember, when we're thinking about what it is that we're not able to part with as part of our basic humanity, the focus here is on our thoughts. And so conveying those thoughts through verbal expression is really what the founders were focused on. Now, you could, of course, make arguments that actually when creating a social contract, people would sacrifice a whole lot less than just the control over thoughts. They would actually not be willing to sacrifice control over their expressive actions either, or not sacrifice total governmental authority. That's fine. Those are perfectly fine arguments to make, but the way that the founders would have resolved those arguments is by asking questions about what would be in the public good. So this gets you back to exactly the Richard Price quotation that you pointed out before, which is that this is exactly the issue. What sorts of restrictions on governmental power are actually in the public good? And so I think that if you want to be an originalist in the sense of just making modern law exactly what the law was in the 1790s, there would be modern speech doctrine would look very different. That isn't the only type of originalism now. So there are plenty of originalists now.
Well, you could argue your own trump card in saying, no, over time we've determined that laws restricting speech because of the chilling effect they have are not in the public good, and that any, justification for those laws in the immediate future would be ameliorated by the long terms concerns we'd have over, the marketplace of ideas, public debate, political debate, things of that nature. And there was actually one founder who did argue that. That was what was her name? I got it somewhere here in my notes. Elizabeth Priestley, she said, government power to regulate harmful speech, once conceded, may be extended to every opinion which insidious despotism may think fit to hold out as dangerous. Was she she wrote that in 1800. Was she a minority opinion then? Because that seems to be our modern libertarian approach to the First Amendment, discussed, what is that, 217 years ago?
Yes, it's definitely a minority opinion, but it's a prevalent opinion at the founding, and one that I think needs to be wrestled with. So the way that we know it's a minority opinion is that it is not the position that the Federalists took. The Federalists took the opposite position, that actually regulating sedition was in the public interest, because individual seditious statements were actually efforts to misdirect public opinion. People were trying to mislead the public, saying false and malicious things against the government. And then the dominant Republican position against the Sedition Act was that sedition prosecutions ought to happen, but they ought to happen at the state level, not at the federal level. And that responded to the problem of jury selection that I was mentioning earlier, because then you wouldn't have a jury that was hand-selected by an appointee of the Adams administration. Instead, you would have a jury that was selected by the state sheriff. And so that would disconnect the sort of partisan interest in the person who was selecting the jury and then the object of the criticism. And so the Republicans really were, in the main, not arguing for this libertarian understanding, but there are plenty of people at the founding who did have a more libertarian understanding of speech. Priestley is one of them. The most famous, of course, is James Madison. In the Virginia Report of 1800, Madison articulates a similar idea that having restrictions of even false and malicious speech can, overall, discourage enough useful speech that it ends up being a governmental power that is not conducive to the public good.
But I want to talk about Madison's report on the Virginia resolutions, because even there, and in this case he's talking about press, which is a little bit different than the freedom of speech, and we can get to that, but he said, the press has exerted a freedom in canvassing the merits and measures of public men of every description, which has not been confined to the strict limits of the common law. On this footing, the freedom of press has stood. On this footing, yet it stands. But so even there, when, reciting this great paean to press freedoms, he cabins it by saying, though those freedoms that have not been confined to the strict limits of the common law. So is even this libertarian Madisonian approach at that time concerned about the common law restrictions?
Well, I think Madison would say that the common law is relevant, so we don't ignore the common law. But Madison was definitely of this less lawyerly interpretive tradition. So he was thinking about what the scope of constitutional rules was, and what the what restrictions would or would not be in the public interest is something that we as a political society can determine for ourselves. We don't need judges to tell us about the proper limitations on governmental authority. And so that was all part of Madison's justification for having state legislatures play a part in trying to figure out what the proper limitations on governmental power over speech and press were, rather than leaving it to the Supreme Court, which was the Federalist position. The Federalist position was, these are questions of law. We should just leave it to the Supreme Court to determine what governmental power does or doesn't exist. And of course, that position was useful to them because the Supreme Court was controlled by Federalist judges who had relatively conservative views about governmental authority over speech.
Let's talk about the distinction between freedom of speech, or the freedom of tongue, and the freedom of the press. James Madison explained to his congressional colleagues in 1794, opinions are not the objects of legislation. However, when it comes to the freedom of press, Jefferson classified this as a fundamental positive right. So can you explain what positive rights are and how the framers' thinking about positive rights versus natural, or today we call them negative rights, would have borne out in reality? And the other thing that confuses me, too, from reading your paper is that you write that positive law should reflect and conform with natural law. So it's very confusing to me. And if you could flesh it out, that would be appreciated.
Yeah, this is one of the most difficult aspects of understanding founding-era thought. And it's difficult because, first of all, we don't think in this way. We don't start by thinking about questions of natural rights or social contract.
Yeah, you say this is a forgotten way of constitutional thinking.
We leave that to political science departments or to religion departments. And then the other thing that's so tricky about this is that the founders just weren't in agreement on the exact relationship between natural rights and positive rights. So on one understanding, you can see how the freedom of the press, the ability to print and publish, would be a natural right. And so sometimes the founders did talk about natural rights in that way. Now, why is that? Well, it's because you don't need a government in order to operate a printing press. So remember, when we're thinking about what natural rights are, we're thinking about, well, what are those things that we could do without a government? Well, you can't have a jury trial without a government because the jury is a governmental institution. You can't have a right of habeas corpus without a government because the government is the entity that is holding the person or providing the remedy for release of the person.
And this is one of the things that was a big revelation for me. You write in 18th century English, the press was a reference to printing, and did not refer to journalists until the 19th century. And today we think, journalists often say, we're one of the few occupations that it's explicitly protected in the Bill of Rights. Lobbyists might say that they're also explicitly protected in the right to petition, but that's not how 18th century founding elites would have thought of that freedom.
That's right. So the way that we could think about the freedom of the press is the freedom of printers and publishers. It's not a freedom of journalists because there really wasn't such a thing as a journalist in the conventional sense, and that was not used in just the founding era idiom. Freedom of the press was not used in that way. So on one conception, we do have a freedom of publishing that could be understood as a natural right. But there's a different way that the founders often talked about the freedom of the press, and that was as a particular set of restrictions on governmental power. And so in that sense, freedom of the press isn't a natural right. Rather, it's a positive right. It's a right about what sort of limits exist on governmental authority. It's a right that's defined in terms of what the government can do or cannot do. And that is what positive rights were. And so what were those set of restrictions on governmental power? Well, the most important was that the government couldn't license printers. It couldn't say, in order to have operate a printing press, you have to get a license first from us. Another important restriction was that the government wasn't able to have a censor who would review the publications before they were published in order to make sure that they conformed with whatever the existing law was. Another important restriction for the founders was the idea that juries should have the ability to decide these questions of intent that we've been talking about. So rather than having judges who were, of course, in the colonial period, royal appointees, rather than having judges decide whether somebody had acted with a requisite malice to commit sedition, we would have juries, that is, people who are from the community, who weren't appointed by the king, who got to decide those questions. And so there's a whole set of specific legal restrictions on governmental authority that are encompassed within this term freedom of the press. And so that's what Jefferson's referring to when he's talking about a positive right conception of press liberty. It's a specific set of rules that limit what the government can or can't do with respect to the freedom of the press.
And informed by historical concerns, thinking back to the Zenger trial, to Milton's Areopagitica and the concerns over English licensing in the 17th century. But they didn't think of this freedom as coming from a state of nature. They said, we've learned that it's in the public good to place these restrictions on government. Therefore, I guess you have to say, use the word granted. We're granting you these freedoms because it's part of a well-functioning democracy.
That's exactly right. So the method for figuring out what the scope of the positive rights was a tradition-based method. It was a common law-based method. But I think it's very important here to note that recognizing press freedom as a positive right did not mean that you couldn't have a debate about what sort of restrictions were or were not in the public good. So I think this is just, I think people misunderstand this aspect of the founding era debates when they say that the only meaning of the First Amendment was that there was a rule against prior restraints. This is a common view that all the First Amendment did was institute what's often called a Blackstonian understanding of freedom of press as a ban on press licensing and on prior restraints. And I think that's too limited a conception, because the founders also had an understanding of the freedom of speech and press as a natural right, and so they also had a way of talking about these liberties in terms of whether or not additional types of governmental authority over speech and press were in the public good. And so in some ways, the paper, this gets back to a point you were making earlier about sort of how the paper is often understood or read. The paper is not just a defense of the Federalist view. It's not saying the Federalists were right, because there's an entirely different way of thinking about speech and press freedoms at the founding that the Jeffersonians had that was very much consistent with understanding of speech and press freedoms as natural rights that wouldn't have limited the meaning of those rights to the specific legal rules that had already been recognized. They would allow for the recognition of new rules that would come through sort of
debate about the popular good, public good, or what constitutes the public good.
We would have these debates in legislatures about what the public good was. We would have these debates in newspapers and in state legislatures and so forth. And over time, we would come to appreciate that there were new positive rules that would then restrict governmental power. This is really Madison's idea here, is we can't cut off the debate by just looking to what the old legal rules were. We need to allow a sort of more robust debate so that we can allow the traditions of legal protections to evolve over time.
But so that idea that we could evolve our understanding of which sort of speech protections are in the public good, the founding era elite thought that would happen through the legislature. But our First Amendment revolution happened through the courts, beginning with Holmes's dissent in Abrams. So that's not how the founders intended for this to go.
That's right. This is a very different understanding of who institutionally it is that is best positioned to delineate restrictions on governmental authority. So for the founding era conception of the judicial role would have been, yes, judges have a role to play in checking legislative power, but they only have a role to check legislative power when there is some already established limit that is provided by either the Constitution itself or by some well-established tradition that would limit constitutional power of government otherwise to restrict speech. And so it's only once we get to the 1920s and 30s that we start to see new theories of judicial review that are more robust, that offer some justification for additional judicial scrutiny of speech restrictions that doesn't exist with respect to other limitations on natural liberty. In the early 1900s, there's no distinct speech doctrine. So you have, if your speech is limited in a way that you think is based on some sort of governmental partiality or an arbitrary restriction on your liberty, you can make a constitutional claim, but your claim is going to be adjudicated under what effectively was substantive due process doctrine at the time, because there wasn't anything special about speech as opposed to any other form of liberty. And so it's only once we get into the famous footnote 4 in Caroline Products about how we protect not only discrete and insular minorities, but we have special judicial protection for the enumerated rights in the Bill of Rights. It's only once we get into that enterprise that judges start playing a more prominent role, and indeed now the most prominent role in delineating governmental power over speech.
Yeah, you talk in your paper about how Madison, how he explained the judiciary, and he said that it has certain discretionary powers with respect to interpreting the means by which government institutes the will of the people, but not whether the purpose or the outcome is constitutional. Is that a correct reading?
That's right. So judges at the founding, the way of thinking about judging in American constitutional history up until the 20th century is to recognize that it's very formalist. So judges weren't allowed to make sort of balancing type judgments about what was in the public interest or not, and they weren't able to make inquiries into whether the motives of the legislature were good or not. And so it's only in the 20th century that we start to see more inquiries into legislative intent. We see doctrines start to adopt tiers of scrutiny to try to interrogate whether the government has really been pursuing this legislation for the right sorts of reasons. And it's only then that we also start to see more robust judicial balancing, where we say, does the government have a really good justification that's sufficient to overtake the speech interest at play?
So then you would argue that, for example, the Institute for Justice's push to encourage what they call judicial engagement would not be an originalist interpretation of how judging was meant to go according to the founding era elites.
That's right. So again, it's not to say that there wasn't judicial review at the founding. There very much was judicial review at the founding, but the form of judicial review was more limited. The form of judicial review was to apply clear established rules. It wasn't to create new rules that would better protect constitutional values. And so that's what modern First Amendment does. We in New York Times versus Sullivan create a new rule because we determine the existing libel law isn't adequate to protect the free speech interest. That's the sort of move that is made in modern First Amendment law that would not have been made at the founding, because the conception of the judicial role at the founding was that they should only be enforcing existing law, which again included traditions that had been well established. So it wasn't to say that there couldn't be the development of new constitutional positive rights that would protect speech, but it's just that the first mover had to be the political process. It couldn't be that judges were the ones who were taking the first steps to establish limitations on governmental authority.
If you have the time, I want to ask you, I realize I've gone over what I told you, but I want to talk about some potential criticisms, because there have been pieces of scholarship written, including recently by NYU professor Stephen Solomon in his book Revolutionary Dissent, that argue that while there might have not been freedom of speech in law, this is both pre-First Amendment and one could argue post-First Amendment, depending on what your conception of the freedom of speech is. He argues that there was freedom of speech in practice. He argues that newspapers operated as if the law of seditious libel did not exist. Americans built effigies, wrote pamphlets, sang songs, and gathered at liberty trees. So while on the one hand, the founding era elites might have thought of this, there to be more restrictions, the people in practice acted as though these restrictions didn't exist. Is there merit to that argument?
There is. I think that this is part of the challenge of figuring out what to do with conflicts within founding era thought. And so one of the things that I'm trying to do in the paper is to embrace that and to say, look, even though there are some common points of agreement among the founders, that speech is a natural right, that there are certain sets of positive rights that impose more sort of determinate legal restrictions on governmental authority. Even though there are these points of agreement among the founders, there are virulent disagreements about exactly what sort of public debate ought to be happening free of governmental control. And so I don't in any way want to disagree. I don't want to argue in favor of there being some uniform view of exactly what sorts of speech restrictions at the founding did or didn't promote the public good, because there were virulent disagreements about that issue. So there are people in England, sort of the radical Whigs in the 1770s, particularly in response to controversy between the king and a Whig legislator named John Wilkes, who had begun to articulate a theory of speech and press freedoms that was more libertarian. And some people were then acting on that, arguing that there should be more virulent criticisms of government. And so I want to embrace the evidence, and hopefully the paper effectively conveys that. I want to embrace the evidence in favor of a more robust public understanding of speech and press freedoms. People who thought that power over seditious libel, for instance, was more dangerous than it was useful. And so that I see that evidence as not inconsistent with the paper, but rather reinforces that actually there were people who had different understandings of the scope of the proper scope of governmental power over speech and press.
Yeah, well, I mean, this discussion about the history of the First Amendment in many ways isn't new. Robert Levy, I believe that's his name. Let me refer to my notes here. Leonard Levy, excuse me. Yeah, Leonard Levy wrote, what is it, like over 50 years ago, The Legacy of Suppression, Freedom of Speech and Press in Early American History, where he more or less argued that the founders had a, circumspect view of press freedoms, and it was limited largely to prohibiting prior restraints, as you mentioned earlier, and that they could restrict ideas that they thought harmful, including attacks on the government. And Leonard Levy reluctantly came to this conclusion, and it was a conclusion that Justice Hugo Black said was probably one of the most devastating blows that has been delivered against civil liberty in America for a long time. But it's also a view that the professor revised in 1985 when he revised the article or revised the book to with the new title Emergence of a Free Press. And he revised it in large part because of the point that Stephen Solomon made in his book Revolutionary Dissent, which is that he found that newspapers in practice were scorchingly critical of the government, and that in his previous article he had been focused on legal theory at the expense of practical reality.
That's right. And so what I want to do in this paper is take that insight and actually apply it to the constitutional debate as well. So one of the things that Levy did not do in the 1985 book is he did not back away from any of his conclusions with respect to the meaning of the First Amendment. So all of his arguments about the meaning of the First Amendment remain the same. And the thing that he backed away from in the 85 book, in the revision 25 years later, was that there was actually a lot of disagreement within America about the proper scope of governmental power over speech and press freedoms. So he recognized that, actually there was a sort of difference of opinion over these questions, but on the constitutional issue, he stuck to his guns. And so what I want to say in this article is, well, actually, even on the constitutional issue, it's not so clear because not only do we have people who are making these arguments about the legal meaning of the First Amendment, the Federalists who are pointing to the common law as the proper source of figuring out what the limitations on governmental authority are, but we have another interpretive tradition at the founding, one that looks more to popular understandings, our legislative understandings of what is in the common good, as opposed to just what judges have told us about the proper scope of speech and press freedoms. And so, that view, I think, complicates even further the history that Levy had presented originally in The Legacy of Suppression.
So, I guess by way of closing, my question is, what do we do with your article? It seems to be that its greatest contribution is an understanding of how natural law and positive law fit into an originalist understanding of the First Amendment. And in that way, I think it sort of departs from Northwestern's Henry Schofield's work in the early part of the 20th century, which I think came to a lot of the same conclusions as yours, but maybe in a slightly different way. How should judges interpret this history? And is it not just the First Amendment jurisprudence that would need to be revised in order to make it consistent, but almost our entire theory of judging?
Well, I don't have any normative take in the paper on exactly what to do with the history. So the primary mode that I write in is as a historian. So I want to recover how folks thought 200 plus years ago. I want to help illuminate how that differs from how we think, and offer some teasing suggestions about how that might matter today without taking a firm position. So I think it really depends on what we think about the proper role of history in figuring out what sort of constitutional rules should or shouldn't apply today. My own view here is that history is important. It's often a starting point for American constitutional interpretation, that it has been for 200 plus years, and that we ought to take it seriously, but that it's not the end point. That we have to consider not just where things began, but also how they've evolved over time. And so new lessons that we've learned from the intervening history, I think, can be incorporated into our understanding of what restrictions on speech do or don't promote the public good in ways that the founders may not have appreciated.
So in that sense,
that's my own take. But I think that whatever use of history one wants to make depends on your interpretive theory. It depends on exactly what type of constitution we have, and how history matters to that constitution. And that, of course, is not, as you say, it's not a debate that's limited to the speech and press freedoms. That's an important debate that cuts across all constitutional issues.
Yeah, so on the one hand, you could argue that our modern jurisprudence requires sort of like a living constitution interpretation, and that to have a true originalist interpretation would be to see a much greater restriction on the freedoms of speech and of the press. That is, unless you view the founding era elites' restrictions cabin to the public good as being allowed to be expanded and intended to be expanded as we as a society evolved in our understanding of the public good.
I think that's right. I think the real challenge for modern speech doctrine isn't that we have developed some new rules. I think that would have been understood as part of the enterprise of developing legal traditions over time that then become entrenched and become recognized as fundamental. That's the very essence of English constitutionalism that the Americans inherited. What would be so challenging for the founders about modern doctrine, and this is something we've touched on, is the idea that judges would be the ones who are pushing the change,
not legislatures.
That's a new development, not legislatures and popular assemblies and and public debate at large, but rather elite lawyers are the ones who are developing new rules. At the founding, there was one side that was championing the views of elite lawyers, but it was in defense of the existing law. It wasn't in defense of the creation of new rules that would promote a value like the public good. And so that is a novel development. But I'll say that is a novel development that, first of all, is not limited to speech and press freedoms. That cuts across all areas of constitutional law. And it's a development that has largely been accepted by the public at large ever since Brown. And so we, of course, have virulent debates about whether certain types of judicial decisions are right or wrong. But for the most part, we now as a society and as a legal profession have accepted the supremacy of the Supreme Court in determining what the Constitution means. And so that's not a defense of judicial supremacy. I'm just saying that that's an issue that's much bigger than speech and press freedoms in particular. It's an issue that I think reflects a very different attitude toward the judiciary than what we had for most of American constitutional history.
Well, Professor Campbell, I think we'll leave it at that. This has been a fascinating conversation, and I thank you for coming on the show.
Oh, absolutely. It's my pleasure.
That was University of Richmond Assistant Professor of Law, Judd Campbell. His article is Natural Rights and the First Amendment, and it can be found in the November 2017 issue of the Yale Law Journal. Before I sign off today, I want to remind everyone that there is, of course, still time to support this podcast before the end of the year. You can do so with a tax-deductible donation to the Foundation for Individual Rights in Education, which makes this podcast possible. If you enjoy what we do every other week, please consider giving to FIRE this month. Donations of any size can be made at thefire.org, and we certainly appreciate any support you might be able to offer. This podcast is hosted, produced, and recorded by me, Nico Perino, and it is edited by Aaron Reese. To learn more about So to Speak, you can follow us on Twitter at twitter.com/freespeechtalk, or like us on Facebook at facebook.com/so-to-speak-podcast. You can also email us feedback at so-to-speak@thefire.org, or call in a question for a future show using the voicemail at 215-315-0100. If you enjoyed this episode, please consider leaving us a review on iTunes. Reviews help us attract new listeners to the show. Until next time, happy holidays, and I thank you again for listening.